Okay, so tonight we're going to talk about transfers after death, wills, intestacy, and probate. Why is it important to understand what happens with death with real estate? Why do you think it's important?
Because you have to figure out who's going to handle the financials and who the house is going to go to.
When somebody dies, they don't take it with them.
Right.
Yeah.
And there's usually some asset that's left, and normally it's the house the people live in. When I worked in the trust department, every day I'd come in, we did probate work. Every day I'd come in and say, I wonder who's going to die today. What am I going to go see? Because that's what they would do. They'd send me out and say, Joyce, go look at the property, because we did not just residential, but we would do commercial properties as well, if it was in the trust, or we were the executor of their estate, and take a look and see if we want to handle it. Because the bank ultimately could become in the line of chain of liability for issues if there's environmental issues and things like that. Even though we were just executor, we kind of got in title, in the line of title. So we would say right away whether we didn't want it or not. So yeah, I did a lot of sales work, was probate work. So we were selling a lot of houses and a lot of real estate just because of probate. Yeah, because families didn't want it, or families couldn't decide what to do. It was easier to liquidate, sell the house, and then split up the money. And a lot of the families didn't live in town with the rest of the family. And absolutely, they wanted the house sold. They just wanted to get as much money as they could. So there was a whole process of going through that. So what we're going to talk about is understand the requirements for making a will. Why is it important to have what is called a good will? How property is transferred under the laws of intestate succession. We're going to talk about the process of probate. We're going to talk about inter vivos trust and a testamentary trust. And then we're going to talk about the benefits of using a trust. A lot of people think that trust is for wealthy people. Well, a good small portion of the work that we did in the trust department was not for wealthy people. It was for people that were handicapped. Their families created trusts to take care of them, so that no matter what happened to the parents, the kids or the people that were handicapped, that they had issues, they knew they'd be taken care of. So again, it's not that way. You know, you don't have to be wealthy to create a trust anymore, and that's not always the driving reason for it. Wills. It's a legal instrument by which a person dictates how his or her property will be disposed of at death. So what is the property? When we're talking about the property that people put in their will, what do they put?
Their possessions, their valuables.
Their valuables, their stocks, their bonds, their collectibles, their personal property, their real property, all of their assets. So when we're talking about property, we're not just talking about real estate, the estate property. We're talking about all kinds of property. So the requirements for creation. Okay, it has to be or should be in writing. We have people that do verbal wills, but we prefer the will to be in writing. They have to have capacity. So if somebody has Alzheimer's or dementia and they're trying to put a will together, somebody can challenge that. They don't have capacity. If they're drunk, they don't have capacity, or stoned, they don't have capacity. We want to have the testator's signature, that they're signing it, and we want to have witnesses. So as they can prepare the document, but then they can go in front of, like if I brought it to the classroom and said, hey, I want to sign this. This is my will. I just want a couple of you to come forward and be my witnesses that I'm signing. That's all a witness is doing, is saying they're watching it signed. They don't necessarily have to be notarized or acknowledged per se. They just need to be witnessed. So, the will. This is just a general outline of how a will is done. They don't have to have all these sections. Some people might not have enough property that they want to make gifts and residual clauses and things like that. But typically it's a publication clause, it's a revocation clause, funeral and death clauses, what's going to happen upon my death, what do I want to happen, how do I want to be taken care of, how do I want my funeral to be paid for, that's part of that clause. Gift clauses, who am I going to be gifting things to, residuary clause, the appointment of a representative. Who's going to be my executor? Who's going to take care of my estate when I'm gone? Appointment of a guardian. That's specifically if you have young children. You'll appoint guardians to your young child. If something happens to you in case of death, who's going to be their guardians? That'll be in the will. A penalty clause, distribution clause, and then ultimately the execution clause. Again, this is just an outline of what would be a typical will. It doesn't mean you have to use all the clauses, but these are the kinds of things the probate court is looking to see that these exist. We have joint wills, created when two or more testators execute the same instrument as their will. That typically would be spouse, husband and wife, doing joint will. We have mutual wills, when two or more testators execute separate wills and make reciprocal gifts of their property to each other. That also could be married couples, on the condition that the surviving testator leaves the remaining property as agreed upon by the testators. We can change a will with something called a codicil. So we've already done this will years ago, but now we decided we want to change how we're going to make distributions. We can form this document a codicil. It's like an amendment. We create the codicil. We want to attach it to our will, write it, witness it, all that, and say this is how we're changing our will. That's a codicil. It can modify, amend, or revoke a prior will without recreating the will. And then we can also revoke a will before death. So a subsequent will or codicil can revoke the will. The testator may also intentionally physically destroy the will, or the will may be revoked by operation of law. Where we would see a will revoking before death, typically it could be couples that decide they want to get divorced. There's a lot of mutual discontent there. They're no longer going to pass it on to the spouse, so they'll tear the will up and recreate a will. Or they've met a new significant other, so they want to create a new will to take care of those people. So that's typically how that's happening. Again, why this is all important in the world of real estate is because this is where we're going to put how we want our real estate or assets divided. We can have disinheritance limitations. We can have spousal omissions, and we can have child omissions. Why would you want to omit a child or a spouse? And that was my first thing when I looked at why would you want to do that? Well, let's say you are remarried and you still have things in your will to take care of the original spouse and children, and maybe that you still want that. But maybe you've got a retirement fund or something else that you can now pass to your second spouse. You can omit your spouse from the will. And that would be a reason for doing it, because you've taken care of them with some other means, with another investment or something. Anybody, and child omissions is the same thing. Kids born out of wedlock, or stepchildren, or people like that, where you're saying that I don't want this child to inherit. This would be a reason why. The challenging of a validity of a will, it can be challenged only by those persons who have an interest or alleged interest in the estate of the decedent. I'm so-and-so's best friend. They promised me that they were going to give me that valuable car when they died. I can challenge the will if that's truly the case, if I can prove that. I don't have to be related to them. I can just be an acquaintance. Most of the times, wills are challenged by family members because they don't get the split that they thought they should get. My sister and I and my brother, when my mother died a few weeks ago, my father died in April, my dad wrote their will so that 1/3 of the estate is split between all three of us. But my brother is the executor of the estate. My brother spent the last 6 years basically helping to take care of my folks, visiting them at least once a week, helping them with their banking, grocery shopping, things like that, as they were going downhill. My sister and I both said to him, Carl, if you can get your act together and get this estate wrapped up in the next couple months, we'll give you 50% of it. First of all, Nancy and I weren't expecting anything to be left anyway. And the reason to do that is it's a prod to get my brother, who would draw this out for the next 2 years, to get it all wrapped up, get it done so he can go on with his life. But my brother sees dollars. Again, it's not a lot of dollars, but it's enough. As an executor, he's only entitled to 3%. Okay, so 3% of $100,000 is $3,000. $3,000 is not a lot of money for all the work he needs to do to wrap up their estate. He had to go get them moved out. He had to take care of their stuff. He didn't have any help. We weren't physically there. They're in Florida. But this whole thing about, $3,000 and then you split it by a third, we basically just said to him, get it done. You can keep 50%. Again, we're not talking over $100,000, but any money that my sister and I saw coming we didn't expect. We truly thought that they would use all the money to take care of themselves. I have this thing with my mother-in-law where she used to joke years ago, we're spending your inheritance. Well, don't ever say that to me. I want you to spend every bit of money you have to take care of yourself and live your life. You know, that I'm not counting on money from my family when they pass. I hope they live full lives and they take care of themselves. But my parents, my in-laws, they're 80, 90 years old. They're still the generation where they have something called depression mentality. They're afraid to spend money on themselves. They'll let the house fall down around them. Now, I could tell when I was in the trust department, all my clients that had depression mentality. I would drive up to the house would be overgrown like crazy. The roof was okay. The heating system was solid. The structure of the house was solid, but they'd never remodeled the house. No kitchen remodeling, no carpeting, no nothing done to make it more livable, make it more comfortable, because they were afraid to spend money. These were people that died with millions of dollars, but they were afraid to spend money on themselves. And I could literally tell it when I drove up, just driving up to the house, by how things were maintained.
So did your interest drop from only 33 to 25?
Yeah.
Okay. But he already had a third. It wasn't just the 3%.
Correct.
So he was at...
He would have had a third plus $3,000 for liquidating the estate. He would have got 33. We said basically you can now have 50%. We're okay with 25. That's still more money than we ever thought we'd get.
No, that seems very fair.
But it's a pride. Like I said, as I told him, I said, this is your kick in the butt to get you to get it done.
Yeah.
Live a life. Go on. Get it all done. Get everything wrapped up and get it done. Otherwise, he'll prolong it. That's my brother. So we figured by giving him that offer, did we put it in writing and do anything in writing? No. But Nancy and I are not going to contest anything either. He knows he can trust us with this. It'll be fine. So again, it doesn't have to be somebody that's related to challenge the validity. It can be an acquaintance or a friend if they thought they were promised something and they have a valid way of proving. Intestate succession. State laws control how decedent's property to be distributed where there is no will, where the will is invalid, or the property was not included in the will. Very common. People forget that they have property, or they forget to write about the house they live in, but they do everything else. It happens. So intestate, for the most part, it's no will. Yeah.
If a person has property in 2 or 3 different states, would that follow the property, the state law, and that's where the property is?
Correct. If it wasn't in the will, the state of where the property resides is where the decision would be made and how it would be handled in that state. Because ultimately, when it's in the state, physically, you can't pick up the property and move it. It's in the state. It's controlled by the state laws. So states take care of it. Yes. Yeah, very much so. So if somebody died without a will and they had property in 3 different states, every state where the property was would deal with what's in the house. So the house could be full of property, of other property. And maybe that person died. Let's say they had 3 properties, but they only really actively lived at one the last few years. 2 of them are basically houses that are shell. They don't have a lot in them. They were just kind of there. And one had almost all the property, but this person died without an estate, well, without a will. That everything that would happen in that particular state where most of the property was, they would govern how the intestate thing would be done. So what the state is going to do, any state is going to do this. They want to go through lineage. They're going to look and see, does that person have children? Were they ever married? Did they have brothers, sisters, family, cousins? Is there anybody still living that's related to this person? And the state will try to find that. The state does a very poor job of managing real estate. They don't want to be in charge of your real estate. But what they do is if they find that they can't find relatives, they will go through a process with an attorney. An attorney will be paid the executor fee in hours. And attorneys are always willing to do this. But they will liquidate the estate. And the state gets the money from the sale of the asset. And they have funds that they put those monies into, good causes and things that the state needs. The state is trying not to get money that way. They get a little bit. It's not a big piece of their budget. But people do die without families, without wills.
And that's a sheet.
That's a sheet. Mm-hmm. So distribution of property with a surviving spouse. Under the state law, title to the decedent's property passes immediately upon their death to their closest living heirs, and typically it would pass to the spouse. But we also have something called dower rights. This is in feudal times. The dower rights says that the spouse gets 1/3 of the estate, automatically 1/3. 1/3 of the value of the house, 1/3 of the right to live in the house, and 1/3 of the property. Because if there's children in feudal times, they always said that the idea behind the 2/3 piece is that that's money that the children can use to survive for their future generations. And that 1/3 protected the spouse. So they had a way to know that they had a place to live and die for the rest of their lives, basically to protect that person the rest of their lives. So that whole thing of dower courtesy goes back to feudal times, and it is 1/3. If you don't have a surviving spouse, it's generally property flows first to the lineal descendants. So there's a chart in your book that shows how they're trying to factor lineal descendants. Again, brothers, sisters, cousins. Property gets distributed to a decedent's lineal descendants by 2 methods. It's called per stirpes distribution and per capita distribution. Now, as far as your real estate test goes, what you need to understand about this is when people die without a will, the state is going to, it's a sheet, the state is going to try to find a way to get the property to their descendants, and they have ways of distributing. Do you need to remember per stirpes and per capita? Probably not. It's not going to be that specific on your law test for the state. But the state is going to have general questions about when people die without a will. It's called a sheet. What happens to the property when they die without a will? How does property get passed down? Again, back to the big 10,000-foot questions of what this is all about. Memorizing it for this test is important because it's our class and what you're going to do, and it's much more detailed. Intestate succession for non-marital children. The decedent's marital status does not preclude distribution of children from a biological mother. They can do for adopted children. Children who are legally adopted inherit just as if they were biological children of the adopting parents. That's what, when we adopt kids, we adopt them forever. And we don't say, but you can't have this, you can't have that. That's not the whole way we're trying to adopt kids. When we take over stepchildren, when we remarry and we have stepchildren, we go through kind of this process, but we may have some exclusions. It's not quite the same as a full-out adoption of a youngster. What's your question?
No, I thought with the stepchildren, I thought they were on like the bottom of the list, past like second cousins.
No, not really, because it's how
There was a chart.
There was a question.
there is a chart.
He showed it.
But yeah, if there's no will.
Yeah.
But when we have a will, yeah,
What we're talking about.
yeah,
Intestate.
yeah, intestate. But yes, they can be outside and very low on the rung to get money.
It seemed like
to get
some
stuff.
of them were like misplaced.
Yeah, and you would think, wait a minute, but these people live with these people. But there is rules. There are old rules, and that's what they go to when they're trying to determine this. Again, do you need to memorize all this for the real estate exam? No. For this class test? No. Just understand that this is out there. So adopted children, they inherit just as if they were adopted. Posthumous children, the child who was born after the decedent's death, may not get anything. And they may have to prove that they really are the kid of the person that died. That's going to be a whole little mini lawsuit all in itself.
I think there was an episode of Law and Order on that.
Yeah. Relatives by marriage usually do not receive any property through intestate succession because they're just relatives by marriage. Murdering. If you murder and you're the heir and you murder somebody, sorry, you just killed your chance of getting anything as well. The states will say, sorry, you caused the death, you're not entitled to anything. Simultaneous death. This is one that I thought was really interesting because I didn't really think about it until, typically when spouses die together on an airplane crash or they're on a holiday or something happens and they die together, we assume that things will probably pass on to their kids or their families the way their joint wills or whatever said. But I didn't realize this thing called this survivor must survive 5 days before they're entitled to inherit because it's a step process. So if two spouses are in an accident, but one lives 5 days longer, everything passes to the one that lives, but then it's that person's will that everything passes down to. It doesn't automatically go jointly. If the one person lives longer, it goes to that person's will. They inherit everything, then it passes the way they want. It doesn't necessarily pass the way they jointly would have done it. So that's why this whole thing about who lives longer, how is it done? We don't really think of these things. We just assume if people die, it's going to happen. But there's a little more involved in it. Probate is the process of administering the decedent's estate. There's a probate court. You go to probate court. My brother, as executor of my folks' estate, will have to file probate paperwork to get everything all wrapped up. And he'll get some help with some, he was sending me the other day, it's going to take a little longer than he thought. We're going to have to pay about $4,000 to have attorneys involved. And I was like, and my sister and I both said, yeah, get it done. Just, pay what you have to pay and get it done. Get the help you need to get it done right. Petition for probate. Probate court opens with the filing of an application or petition for probate. And then they will appoint a probate representative. It's a representative of the estate appointed to administer the estate. If somebody is not already appointed the executor in the will, the probate court will appoint the executor. In the trust department, the way our trusts were always set up, if people died, the bank was the executor of the estate. And that was...
The 3%?
Huh?
Did the bank get the 3%?
Yeah. And my direct boss was the guy that did probate work. When people died, he knew exactly how to find stuff in their house. He knew all the hiding places. He knew how to go out and find their old retirement accounts. He knew how to go find their history biologically. Where did they work? What did they do? He could actually knew how to go and find all that old money. So I was telling my brother the other day, I said, I know my dad took out an insurance policy on my mom when he worked for General Electric. It was a spouse policy. Got it for a pretty low price. Is it still in existence? I don't know. Don't know how to go call GE to see if it's still in existence. My dad worked at GE for just shy of 40 years. They forced him into retirement. But I said, there's probably something there, maybe $10,000, but it's probably worth trying to find out if something's there, if he hasn't been able to find all the paperwork. Because my dad didn't share all the paperwork with my brother. It was in a pile in drawers. So it's up to my brother to go through piece by piece. This is the other thing about trying to get this done. It would take my brother years to go through that drawers. He needs to go through it months to get it done. That's why we're trying to urge him on. And if he finds more money, that's great. But again, it's this whole thing. He was appointed executor in their will, so he'll take care of it. I used to be the executor. My dad changed it to my brother. When my dad owned investment property and I was working for the bank in the trust department, my dad made me the executor. Yeah, they were in Florida and I was in Ohio, but I was working with those kind of things. And my dad knew I had contacts to help get it all done. But then when he sold off all the rest of his property, they moved to a retirement home, they named my brother the executor, which is totally fine by us. It's better that it all be done down there in Florida anyway. Collection and distribution of the estate assets. During the probate process, the executor administrator collects all of the decedent's assets. This is the detective phase, going through, finding out where did they have bank accounts, what credit card accounts, what do they have, who can make claims against them, where do they have money coming in. It's a mystery because people die and don't give you all these clues. They don't tell you everything. Even as much as my brother was keeping my dad's bank accounts for me the last few years because my dad couldn't see well, my brother still doesn't know everything. The inventory is sent to all the estate's heirs and beneficiaries so that they can see openly what it is. Again, this is going through a court process, through an ordered process. You can buy property from a probate estate. When a person wishes to purchase property from a probate estate, the sale has to be approved by the probate court. So when we sold real estate, we would go and get an appraisal done. This is one of the, why do you have appraisals done? It's one of the things in your class they're going to ask you on your P&P test and everything else. Why do you have appraisals done? Well, when people die, you got to value the estate. When people get divorced, you got to value the estate. When people want to sell a business or sell a house, you have to value the estate. When there's insurance involved, you get appraisals done to value property. So what we would do is we would call an appraiser in, we would value the property in the condition it was in. As an executor of the estate, it's not our job to go say, hey, it's worth $50,000, but I'm going to ask 100. I'm going to negotiate to 100. Not our job. Our job says if it's worth 50, all we got to do is ask for 50. And as is, where is. As the executor of the estate, we didn't have any experience with the property. We didn't know when it flooded, when it got wet, what electrical problems they had, what roofing problems they had. What you see is what you get. And I would write on the top of the property disclosure form that I was selling as executor and I had no experience with the property. That's all we're required to do in Ohio. Just to say this is what it is. But we were there, so I would have a guy that would call me all the time and say, what houses do you have for sale? Because he knew he could buy them for that, just that low appraised price in the condition they were in. Again, these were the people that died with the depression mentality. The houses hadn't been remodeled. Good bones, but they hadn't been remodeled. What are flippers doing today? They're buying exactly this same kind of house just to remodel it to make it more current. Open up some walls, put modern appliances in, put a modern kitchen, bath in, it's ready to go. These are good houses. So, when you're doing real estate, you're going to end up involved in selling estate houses. You have to understand that you're going to go through the probate process. What are the requirements? You have to present the offers through the probate court and get things approved. That's really all you're doing. But you're selling it, and the probate court or the executor is going to be the one that will sign the deed and sign the closing statements. Closing of the estate, once all the foregoing activities have occurred, the estate may be closed. And closing an estate from, again, going through what I'm seeing, going through 6 months to a year or so after people die would be a typical window to get things wrapped up. But there are people that will wait years. They literally will wait years to get through their family's properties. There's nothing that says it has to be closed out right away. If the family inherits everything, they can take their time and go through it. There's nothing that says the property has to be sold right away.
It's just a tax nightmare.
Yeah. Yep. Okay, trust. A trust is a legal relationship in which property is transferred by the settlor or trustor and held and managed by the trustee for the beneficiaries named in the trust. What was interesting about beneficiaries named in a trust? Beneficiaries is everybody that's living, but it's also the unborn heirs. Because if a trust can go on for many years, ultimately there's children that will be born to the heirs. So when we're acting as a trustee, we always have to remember we have to act in the best interest of everybody, the future generations and everything. So the types of trusts we have inter vivos trusts, which are trusts created during a trustor's life for them to work and live off of, and they get benefits from their trust in life while they're alive. And then we also have testamentary trusts, which is a trust that takes effect upon a settlor's death. So the trust is everything's in place, but nothing's happening to make disbursements or do anything with the trust until everybody dies. Most of the trust work that I worked on was inter vivos, but some of the stuff we had were testamentary because we had, when I worked at the bank, we had people that came to the bank in the early 1920s and set up trusts. Those people were long dead. It was their great-grandchildren that were now beneficiaries. So they were testamentary trusts. They were formed a long time ago. And we were having to distribute and follow the rules of what they wrote many generations ago. And I had a guy that lived out in Adams County, or no, beyond Adams County, out near Ironton. And he called me and he said he wanted to know what was in his family trust. Why didn't he get his check? And it just came down to money. But the guy was a nut, and I would never go see him. We did drive by his trailer one day, and we verified with the mailman that that was where he lived, but we didn't go knock on the door. But his family also had a farm that was down in McGoffin County, Kentucky. McGoffin County is down at the end of the Mountain Parkway. It took me a day to drive down there and drive back. And when I went down there, his family had 25 acres at the end of the parkway. And the 25 acres, 5 acres sat on one side of the street, 20 acres sat on this side of the street. To go to that 20 acres, there was a little creek. You crossed over the bridge, the creek. There was a railroad track. I mean, it was like everything that could happen was happening in this little piece of property. The guy next door, part of it had been strip mined. He called me. He wanted to buy 5 acres, so he took me to the property. He took the cattle fence, loosened it, so the neighbors next door were trespassing and they had cattle lines drawn. He took me up to the property and there was a cemetery for a family down the road. And Grandma's grave was still ready. She hadn't died yet. So the rules of those kind of things is that family that had the graveyard there had to have access forever. You always had to be able to give them access to the property. Over the bridge, unhook the electric, come on in and you can do your thing. But there was a foundation of the house that burnt. And it was this crazy guy's family. And he said, I'm going to go down there and build me a house. And we kept going, right. And I said, no, I got an offer, I'm going to sell. Oh, no, you can't sell the property. And he told me one day, he says, what burns faster, gasoline or kerosene? I'm going to sit here in the bed and watch this show or whatever, and I'm going to commit suicide. I did not come to the front of the office for a couple months without worrying, was this guy going to come hunt me down? Seriously. And then when I finally sold the property in McGoffin County, he called me one day, and I said, well, kerosene burns better. Just go ahead and do it. Don't worry about it. I was getting, what? Oh. Well, what happened? I said, I sold the property. Well, where's my money? That's really all it was where's my money? But, again, this was a testamentary trust. He was the beneficiary of a trust that his parents had set up and died a long time ago. He was fairly old, too. Just a weird... We did find a family down there to buy all 25 acres with all the problems. In McGoffin County, the appraiser and the undertaker were partners. Everybody in the county does everything. It's in the hollers of Kentucky. Kind of interesting thing. A revocable trust can be changed or revoked at any time prior to the trustor's death. So typically what we write today, let's say I wanted to write a trust today, I can make it revocable, saying that I'm going to call it a revocable trust because things may happen in my life to make me want to change the path of where I'm going with this. So that's why we would write a revocable trust. An irrevocable trust is a trust that cannot be changed or revoked during the trustor's life. You're casting everything in stone at that point in time. So there's a lot of thought and process that has to go to that. The irrevocable trusts are the people that are wealthy. They're still getting enough income to live off of stuff. So no matter what happens with their life, they don't have to change things major. They're still getting things. Benefits of using trusts. The assets in the trust are legally owned by the trust and are not considered part of the estate. So they don't have to go through probate as much. There's a lot of privacy in the distribution of the estate assets. So it's not of public record anymore. Everything's in the trust. It gets distributed the way you're told to do it. It doesn't have to go to the courts or anything like that. Everything's already pulled aside. A lot of the things that people do with trusts, they also try to avoid taxes. It's generation skipping. They can not pay taxes by skipping generations to do things. This is all part of financial planning. That's why a lot of people think that trusts are for wealthy people, because you're getting a financial planner to help you get it set up, because it is a way to avoid taxes. But it's not only for wealthy people. There are good reasons to use them. That's it for trusts and deaths. Any questions?